I kind of sense there's some kind of, uh-oh, they're recording me. I better not swear. Um, okay, so there's some, I think just kind of misconceptions a little bit about it. So I will, if you bear with me, I'm going to go through some little beginnings of copyright. I pride myself on being able to do all of copyright on one screen. Um, so this is one slide, U.S. copyright law. Just so you know what it is something that's in the statute. It's Title 17 in the U.S. Code. It's written by Congress. It was first talked about in the Constitution. And for the progress of science and useful arts, we're going to have a copyright law. Basically told Congress that they can create a copyright law to advance the progress of science and useful arts. And what the founders were thinking at that time was that they wanted everybody to have access to information. They were thinking that in a democracy, everybody would have to have access to the laws, they'd have to have access to news, and so they really wanted it to be as open as possible for people to find out things. And one of the ways they thought they needed to do that was to encourage people that are writers or creators to share their work to the public. And the way they thought they could do that is by giving them a statutory monopoly, allowing rights holders, authors and creators, and maybe ultimately publishers and movie studios, the exclusive right to sell the work that they created. So it is something that they weren't very keen about. Monopolies were not favored, but they thought that if we give these folks a monopoly, they'll be more likely to share what they've created, and it'll be for the good of all of the people in the democracy. However, the statutory monopoly is limited, so there are some constraints on it. It's not a complete monopoly, and the limits that we see are the kinds of things that we have, like the public domain and what can be protected, and government documents are not protected. Those kinds of things are what are the limits to the monopoly. The other thing about the founders is that unlike a lot of copyright law in Europe, the founders really looked at the law as not being a natural right, meaning it wasn't something that authors just should have or are guaranteed or are due this monopoly. It's not because they're special people that they should have this monopoly. So they didn't like heighten the author or the creator as somebody special, and not that they were creative because it was a natural thing for them. There's a lot of European nations, they think of it that way. They also didn't think of copyright as being a property right. So when you hear people say intellectual property, that's really a misnomer. For us, property is like owning your home, owning your car, but a rights holder doesn't really own the material that they create in this country. Instead, they're given these rights to allow them to monopolize on whatever they create. So the only reason they have this monopoly is for utilitarian reason. If we let people have a monopoly, then they will share their work or sell their work and make it available to us. So it's a means to an end. We wouldn't have the monopoly if we couldn't guarantee that people would provide their work. This is a really important thing to understand because from the get-go, you can see that the law in the United States is more about the benefits to the public than it is about the creator. And that's kind of hard to say to like an author, like your rights are like not as important as the people's rights ultimately. But in our way of thinking about the copyright law, that's why we have it. We do it just so that people give us works, and we feel like they should get compensated. That's all great, but that's just a means to the end of providing access. In the Constitution, right after the copyright clause, the next clause is about Congress shall create a post office system. And these two kind of things kind of relate because they're saying that Congress was so interested in providing access first by developing a copyright law that would benefit the public, but then also by creating this post office system to ensure that access to materials would be widespread. So this was really at the top of their heads. They were thinking about this really big time. What copyright protects is original creative expression. So there's other intellectual property laws that protect other things. There are trademarks that protect, you know, a little mark that identifies a product. There are trade secrets. There are patents. These are all different kinds of intellectual property. In general, we're mostly talking about copyright law in the libraries and in teaching. A friend of copyright law is licensing, but it's a state law, but it's very much used with copyright law, even in the analog environment. We think about licensing only in the digital environment, but even in the analog environment, licensing is really key to copyright. The rights holders have these exclusive rights, and those are probably real familiar to you. And these exclusive rights, reproduction, etc., are divisible. So they can be separated out. And so let's say this is when a license opportunity comes up for a rights holder to maximize, you know, their money as much as they can. They might say that, you know, in your classroom, you can have the non-exclusive right to publicly perform a movie in the classroom, and you have to pay them so much money for that. So they're not giving you the right of reproduction, they're not giving you the right of distribution, they're just giving you the right of public performance for a particular period of time, a non-exclusive right, meaning they can give that public performance right to whoever they want. And so that's how the licensing part of it is connected to copyright. The rights are divisible, and sometimes you have situations where you have many people owning different rights for the same thing. That happens a lot in music. They also can be inherited, and they also can be contracted away. And you'll see this a lot when in a scholarly journal market, professor will sign away their rights of copyright to a journal publisher in order to get published. So you can just give up your rights altogether if you choose to do that. The other thing about the creative works is that they've got to be in a fixed, tangible medium. That's what the language that they use. So people must be able to perceive the works. It can't be something that you just have in your head. You know, it must be something that's written down as perception. And then the very important thing is the distinction between the copyright and the copy. You may buy a copy of a book, and that's your property. That book belongs to you. It's really your property, but you don't have any of the copyrights related to that item. So the rights still stay with the rights holder, and you have just the copy. And you cannot ordinarily exercise any of the exclusive rights with that copy unless there's an exception. So that's like the big picture of copyright law. It's really about the public interest and about access to information, and that's why it should be like extremely important to librarians and something that we should champion as much as we can in our jobs. Does anybody have a question about that? Doesn't it sound like copyright is so good when you look at it that way? To me, it sounds like, oh, that's so cool. They were wanting people to be able to have access to information. Now, the next slide, let's see, talked about the limits, and the monopoly is limited by these things like fair use, which you've heard of, first sale. Really important to libraries is once you own a copy of a work, you can give that copy away, you can lend it, you can sell it in a secondhand bookstore. This is first sale, important for libraries. Obviously. Then there's interlibrary loan, there's all kinds of other things. There's the public domain. Once something is out of protection, it belongs to the entire world, it belongs to all of us. We can do whatever we want with it. Publishers use public domain books to, you know, resell them a lot, like Penguin Classics. You know, they don't have to ask anybody for permission. The term of the copyright is life of the author plus 70 years. which is really obscene and stupid. Because you can see it kind of gets away from the notion that we have to reward authors in order to get them to create. When you have a current term that's life plus 70, it means the author is dead. So you're not really rewarding the author if they're dead. Instead, the law has evolved to be kind of a reward for copyright errors, a way to control content for big companies like motion pictures company and stuff for as long as possible to squeeze out every little bit of penny they can out of it. So the term is really long right now, and it's not a good policy, not a good public policy. And then there are limits on what can be protected. I mentioned federal government documents, facts. You can't protect facts, and there's a reason for these things. If you could protect a fact, you would have to ask the person who found the fact if you could use it to do your work, and you could see what a stumbling block that would be in science to have to continually ask to be able to use a fact. So the founders and the Congress were really smart about the way they plotted out the copyright law. And then another thing I like to bring up is there's a difference between the expression, the creative expression, and an idea that you might have in your head. So I always use, my favorite example is the soap opera genre. The soap opera genre, which I love the soap operas. I love The Young and the Restless. And it's not on right now because they're just showing repeats because of the global pandemic. But if you know soap operas, it's always the same kind of story that happens. There's an issue about who the father of the baby is, paternity. It comes up a lot. Sometimes there's like all of a sudden you find out this person has an identical twin. That will be a thing that comes up a lot. Same story. There will be the instance where there's a snowstorm and a pregnant woman is trapped in a cabin and she can't get out, and it just so happens she's with a guy that helps her deliver the baby. And then 3 or 4 years from now, then you find out that that guy is actually the father of the baby. So you know all these like different stories that are typical of soap operas. Those are ideas, but each time they're presented in a different, original, creative way that allows them to be protected. So just the idea of a woman in a cabin or in an elevator that's giving birth to a child and is trapped is not copyrightable. That idea isn't. But the way you might express it and film that and act that and how you have a script and everything is what's protected, which is kind of very important, I think. Okay, now I was talking about Congress and the founders. They based the law that we have in the United States on the Statute of Anne, which was the law in England at the time. And if you see, the first sentence says that it's an act for the encouragement of learning. So the founders really kind of built off on that. You can kind of see how they were talking about the public interest and people having access to information. So learning is a huge, huge thing about the copyright law. And it has a big impact on us. So if learning and socially beneficial uses are the purpose of the copyright law, these are the kinds of things that we have to have a limit on. So we have classroom exceptions to allow us to do learning. We have public performance in the classroom. There are things in the law that give special privileges to schools, to libraries, to higher ed, to researchers, to archives, because these places have a special status in the law because they are places where people will learn. And that's why they're special in the law. And a nonprofit educational institution and a library are like the highest special things in the law. That's why the library associations can have a big impact on lobbying on copyright, because we're like a really big deal in the copyright law, which is cool. And then I wanted to mention fair use, and then we're going to go on to some of your questions. Fair use is, years ago, I used to ask people if they knew what fair use was. Raise your hand if you know what fair use is, and a lot of people didn't. If you raise your hand, do you know what fair use is for the most part? Think you know it? Yeah, okay. It's a part of the law. It's in the law. It's based on court decisions that occurred over the years where somebody would be brought to court and the rights holder would say this person infringed, my rights, and the person would say, the accused person would say, well, my reason for doing it was because of this, that, and the other. And so the court started to see, well, there are some reasons that, yeah, people could exercise a copyright and actually not be infringing. And those kinds of instances are called fair uses. And so through that common law, they established these 4 factors that we use to evaluate whether a use is fair or not. And those factors, you probably know: the purpose of the use. Why are you using this work? Why are you exercising an exclusive right of copyright? For what purpose? And each factor is on a continuum. So you're thinking about what is the purpose of the use on the one side. It could be completely nonprofit, completely educational, all socially good. On the other side of the spectrum, it can be for commercial purposes. You're riding on the backs of a rights holder. You're, making money that you shouldn't be making. You didn't contribute to the work. You could be really bad. So the factors are on this continuum. Sometimes things are very, very fair. Sometimes things are kind of fair. Like, if you're in a private institution, if you're not in a public institution, you're not very, 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 very nonprofit, but you're closer over there than you are to being like a thief. So it's on a continuum. The nature of the publication is discussing the kind of work that you're using. Creative works like fiction and poetry and motion pictures have a thicker layer of protection. Based on court decisions, the courts have decided that these works are more creative, and so they should be protected more. A scholarly article is not as creative, so it doesn't get as much protection. This also has to do with publication status. If a work is already published and already has had its opportunity in the marketplace, there's more latitude for being able to use that work than if it was something that was unpublished and never had its opportunity in the marketplace, because it's thought that the rights holder should be the one that makes that determination when to market their work. So when you're looking at unpublished diaries, these are things that are very highly, highly protected, because whoever wrote the diary did not necessarily want it to be sold or in the public realm. And so those things are protected more. The amount of the work is the easy one. Less is better than using the whole thing, although using the whole thing is absolutely fine given a particular circumstance, and we'll talk about that when we talk about reading aloud. And the effect on the market for the work. The simplest way is to think of it as, I'm using this work to avoid a sale. That's infringing. I'm using this work to kind of, get around the system. This happened in Houston, a school district, where they had been very blatantly copying workbooks and, kind of joking about it. Sending emails and saying, we're just going to ignore this like copyright notice and just make a bunch of copies. It was like very, very, very bad. And they got in big trouble and a big penalty that school district had to pay to the rights holders. That's like a really bad thing, definitely an effect on the market. We have these other things like permission fees. Some of those are really well established, like in the motion picture industry, showing a film in, an exhibition. It is the way that movies, especially in the past, made money through ticket sales. So that is a very established market where usually you have to get permission. But then there are other markets, for photocopying market, other things like that, that are there and established, but not necessarily something that you must use. And we'll talk about this a little bit more. So the thing to remember is that these factors are on a continuum. One or two of the factors tend to make more, um, have more of a standing in the assessment. They're more important than the others. Sometimes one is like super important. I can give you an example where The nature of a publication, which you wouldn't think would be ordinarily that important, was important in this case where the publication, The Nation, got hold of Gerald Ford's unpublished manuscript. And in that manuscript that was like 400 pages, The Nation chose to print the part of the book that explained why Gerald Ford pardoned President Nixon. Kind of the heart of the book, only like 4 or 5 pages of the book, but it was unpublished and it was like the most important part of the book. And that's what the court really looked at when they considered the 4 factors. They considered the effect on the market. I mean, it would be not as worthwhile a book to buy if you already knew what the idea was about Nixon, but it was that particular use that they really focused on. And so in that instance, factor number 2 was really important. That's not usually the case, but sometimes it is. And the other thing to mention is that there's a trend in the courts in regards to the purpose of the use. The first factor, and this you might have heard of, is this transformative use. And courts are focusing on those uses that take a protected work and use it in a way not intended by the rights holder and create something new. The best example is like Google or search engines. They routinely copy everything that's on the web over and over again, constantly without authorization in order to create a search engine. Now, ordinarily you'd go like, wow, that's rapid infringement, it's just constantly, but they create a search engine out of that, and which is a socially beneficial thing. And so that is something that's considered transformative and something that should be allowed to happen. And so early on when we had search engines, there were a lot of decisions that pointed to that kind of issue. There's other decisions more lately. HathiTrust is a transformative use, and this is where Google with research institutions copied books, completely copied all these books without authorization, but again to create kind of a search function, and that was transformative. There are other examples that if you want to know about them, I can tell you. They're kind of interesting. Okay, so now we're going to get down to some of the questions that I got. Does anybody have any questions yet, or do you want to challenge anything I said? There used to be a time where I would say something like this and people would go like, what are you saying? What are you, a
Carrie, I have a
communist?
question for you.
I have a question too.
Yes.
Go ahead, Donna Jo, you go first.
Okay. Sorry, I'm going to have to leave for another meeting at 11.
That's okay.
But when we read books for the kids, and now that we're having to do it online, is there any copyright issue on that? Us getting a book and reading it to the kids, and if we put it on YouTube or something like that, is there an issue there?
Yeah, reading aloud. This is one of the questions that I was going to address, and let's do it now since you have to leave. The question was, are there any guidelines about reading aloud? I got that from Matt. There's no guidelines. There's no such thing as guidelines, fair use guidelines. That's all made up stuff. You have the fair use thing, you don't have guidelines. Just let's get that out of the way. So is it illegal to read books to students on Zoom during a national pandemic? So let's go through the 4 factors. Why would you want to be doing this? Well, I think you want to do it because you want to continue education in distance education. So that's a good thing. So that is the first factor. It's fair. Good. What title are you using? What is the nature of the publication? Well, I imagine you're using stuff that's part of the curriculum. And so you would use that because it's part of teaching, right? Or you might be using a children's book, a picture book to read aloud to kids. So in this instance, the title doesn't matter that much in terms of your assessment. So we can just pretty much put that aside. How much are you using? You're reading as much as you need to meet the teaching objective. Sometimes that means the entire work to meet teaching exception. So that sounds good too. Is there a market impact? No, because you've bought the work. You probably have copies of all the books in the library and none of the kids have them at home. And so you're reading from books that they don't have but have already been purchased. So for me, reading aloud in the classroom is using Zoom or any other technology is a fair use and is nothing that you should be concerned about. Moreover, there is another part of the law that's it, the TEACH Act, Teaching, Education, and Copyright Harmonization Act. That was passed in 2002. And this is when the Congress was trying to recreate the kinds of exceptions you have in the face-to-face classroom, in the distance education classroom. And they said in that law that you should be able to do pretty much the same thing. But they put in some prerequisites, which is what you can do to kind of protect the use. And those kinds of things are like password protection, putting it on a private YouTube site, or only using the material for as long as you need to use it, those kinds of things, which are pretty much common practice that we do already. So those make it even more of a fair use because you kind of have fair uses there, but you also have this exception that says you can do it. So you have like both. So I would have no concern at all about reading aloud in the classroom. Now what we've had is we've had a lot of nice publishers give us works that they are saying we can use freely, which is great. When those things are no longer free, that doesn't mean that the fair use argument went away. The fair use argument is still there. So I have absolutely no concern about reading aloud as being a fair use. Could you pay for it? Could you pay a permission fee for it? Yeah, you could, but you don't have to because your use is fair. Does that make sense?
Yes, thank you.
Yeah, that came up, for a long time now, when you first think about it, you just use your common sense and you go, is it okay to read aloud to a group of kids? Kind of sounds like, yeah, that's okay. Should be okay. It's sad if we are in a state of affairs that would not be okay.
And then, Carrie, there is the related issue of, is it okay to record yourself reading aloud? And
Yes, if there is a reason to record yourself, yes. I mean, if
okay.
there's a teaching reason to do it, let's say maybe you're recording yourself because not all of the students can be in classroom at that time when you do the reading live. So maybe you save a recording for them for later. You make sure it only goes to those students. So recording is fine. Is it okay to put it on live YouTube and it's on there forever? That is probably less fair because the teaching argument is not as strong, right? Because it's there forever and you're not always forever teaching that class. But it may be one of those uses that are quite transformative, which would maybe make it more of a legitimate fair use. For example, there may be people that are in the class that English is a second language. And so the reading is taking place in a way that's different than, if you just got an audiobook and just listened to it. If you paid for an ebook or something, the teacher might be emphasizing certain words. You might be using a large screen projector to like put words out and have pronunciation and all this stuff, and it's all part of a storytelling thing. Well, that would be a transformative use that would lend itself to a fair use argument.
Got it. Okay.
So it's not,
Carrie,
yes.
if I can expand on that, because I've always felt like teachers doing that with their students falls into fair use. What about principals, camp directors who want to record themselves reading a book, a picture book, and put it on Facebook?
Yeah, well, again, we do the fair use analysis, right?
Right.
So why are they doing it? Well, it's
Fine.
not all the way over on that continuum of education, nonprofit education. It's not like all the way over there. But on the other hand, it's not like a for-profit operation either.
No.
So there's this continuum, and it's a little bit more towards the educational use. So you have to weigh that. It's not like pure fair use educational, but it's way over there. And so that's how you would look at that first factor. And then considering the other factors, you could make your determination on whether or not it would be fair. In general, I think those things are okay. I had someone ask me years ago if it was okay for the principal to read a poem aloud at the commencement. And I'm like, really? Of course you can do that. You know, just because it's the principal and not the teacher, it's okay, you know. Can you make a photocopy of the poem and also like hand it out to everybody? Well, why not? Yes, you can do that. It makes sense that you should be able to do that. A lot of it's kind of like, yeah, it's okay. So, are there any other questions about the reading aloud? Now, there are other people who would argue.
I do have a
Uh,
question.
Sure, go ahead.
That I have completely forgotten right now. I'll have to come back to it. Sorry, I was so busy
Oh, that's
unmuting
okay.
myself,
That's
I forgot
okay.
my question.
We can do all questions all the time.
Okay.
There's the dog. There's the Chupa. Isn't that the cutest dog? I love that dog. So you remembered it, Anna? Did you remember your question?
Not yet. I'm gonna have
Okay.
to maybe capture it this time.
Okay.
I'll
So
get back.
I would say there are people that argue against what I said. There are people that say you must ask permission all the time for everything. I don't think that's a good reading of fair use. But there are people that say, well, just to be on the safe side, I might as well ask permission.
I did
Well,
remember.
okay, go
I'm
ahead.
sorry. I have often said that, you know, in the terms of affecting the market or whatever, that it would be a reasonable argument to say, you know, so I'm, you know, using 1 or 2 poems or a big chunk of, say, an epic poem, but it's kind of a big chunk. It's not really affecting the market negatively, but there is the potential that I'm actually using this thing as advertisement, you know, that somebody might want to go write, you know, buy the whole book of poems or something. Has that ever been used in court or as a legal argument in defense to push it towards the fair use side?
Yeah, I have seen that in some arguments. In Hati Trust. Are you guys familiar with Hati Trust? Yeah. In Hati
Use it
Trust, there
all
was,
the time.
yeah, it's great. There was an
All the
argument that, you know, because people would be exposed to all these books that they might ordinarily never have access to, that they would go ahead and buy the book. And in Hati, you know, you only get a little snippet of the book that you can actually see. And a researcher might go, gosh, I didn't know about that title. I'm going to buy it. So yeah, there are arguments like that where it's actually a benefit to the market. We would argue that public libraries are a benefit to the book market, you know, because you're exposed to all these books and then you want to buy them. So yeah.
We
So
had a parent read a book aloud, and our school put it up on, you know, out to the public, and it was purely for entertainment purposes. So we chose, you know, I spoke up and they took it down. I'm from what I'm hearing, I think we did the right thing. Am I right?
Well, yeah, I mean, again, it's a judgment call, and you can definitely see that in that instance. You don't have that first factor really weighing heavily in your favor. It's not absolutely, you know, for profit, but it's not educational on that other end of the spectrum. So, you know, you have to make that judgment call. Now, there may be a reason why in certain situations you might be able to argue that that entertainment value is actually very, very socially beneficial, you know, depending on whatever it might be. But again, it is a judgment call, and you won't know for sure if you're right unless you're sued. And you're not going to get sued for a lot of different reasons, which I can expand upon. But ultimately, you know, the court makes that final decision. And then there's an appeal process. So then the court makes another decision. So you won't know for sure, but you have to feel comfortable making that judgment call.
Carrie, I just have a quick question. Back in the old days when I was at UVA and working with Madeline Wessel and wrestling with video copyright issues all the time, Kenneth Cruz checklist for
Yes.
is that still like, so if our members here are interested in looking at a checklist and sort of seeing the continuum and more information, is that still considered like the go-to?
I think so, yes.
Okay. So, and
Yes.
I'll just tell all the members here, I will, when the meeting is over, I'll send out links to that and to Hati Trust and some of the other things that have come up in case you want to do some more reading.
Yeah, Yeah, and one more thing about the guidelines, a lot of people, they practice this thing where you can use 10% of a book or 5 lines from a poem, that kind of thing. Have you heard of these things? Ignore those. They're made up. They're made up. They're not in the law. If you use that as a defense, the court would say, I don't care. I don't care that you have these written down guidelines. They're not in the law. So don't use those. Usually it's kind of, they're arbitrary, for one thing. Always thought like, well, we'll photocopy 10% of this book, but damn it, we won't photocopy 11%. No, no, no. I mean, you can
Mhm.
see that's kind of silly. Sometimes photocopying 1% might be a violation of copyright law. So don't use those ever. It does
Carrie,
mean you have to think more, but don't use those.
did that 10% rule, I know it was floating around for a long time, but then several years ago in the Georgia State's case where they were doing all those photocopies for reserves, wasn't the ruling in that case, didn't it specifically say 10%, no more than 10%, or one chapter of a chaptered book?
Yeah, the judge did use that, amount kind of, criteria. On appeal, the court said, really don't use that. It's not like a
Oh, okay, good.
formula.
Okay.
And then when it went back to the judge, she again used kind of this notion of it wasn't that much, but she did stay away a little bit more from like the 10%, and that's it. She kind
Mhm.
of looked at she looked at each one of those titles and the use for each one of those and just made an assessment, a fair use assessment on each and every one of those examples.
Mhm.
And I don't know, there were 94 of them total ultimately, and like 4 or 5 of them were infringing.
Yeah.
The latest, I can't remember, maybe 7 now, because they did another ruling. That thing will never go away, Georgia State.
Mhm. And then I have one more thing that I want to ask you about, and then I'll let you get back to your presentation. But it does have to do with the with fair use and the 4 factors. And I know from my own experience and from many of my colleagues, librarians, we like having checklists and we like having things clear cut. And that's
Yes.
sort of an issue with the, which you touched on with the fair use guidelines, is there's this continuum that it's not a checklist where you can say, okay, I got that, okay, I got that, okay, I got that, okay, I got that. And so I think that's one way in which a lot of times librarians and teachers and administrators have a hard time sort of judging whether or not something is fair use because they want that checklist aspect, and that's not what it is.
Yeah, I think I'm a librarian, so I can say we're very rule oriented as a profession, and so we do like these kinds of yes and no kind of things. I can see using guidelines for, let's say you have a massive, photocopy center in your library and you have a bunch of student assistants that work there and they can't possibly do a fair use assessment all the time. So you give them some general guidelines, don't let the person photocopy all of the whole book or, whatever. I can see where you might have rules like that for like mass photocopying. But what we really would like to see is for librarians and also for teachers to start to be able to feel comfortable doing the fair use analysis, because if we didn't have fair use, we would be so screwed. We would be so, so screwed. We have to really rely on it and use it.
Can I,
Anna,
can I chime in about the fair use checklists? At my school, I tend to use the one that Columbia Libraries has sent out that, has the 4 factors, but then there's different criteria within those 4 factors. And so what I try to convey to my teachers who want, a yes or no answer, or they want it to be 3 to 1 in their favor or something like that out of the 4 factors, I just say that if the preponderance of it favors fair use according to this checklist, then you're good.
yes. I think in general, that's a good thing to do. It's the same checklist that Matt was talking about from Kenneth Cruz, who was at Indiana and then he went to Columbia. So yeah, that's a really good checklist. And I think it's very helpful. sometimes people go, well, it's 2 for and 2 against. What am I going to do? You got to really think through it. You have to understand the nuance of the use. You have to understand that some factors are going to be more important than others depending on the situation. Like sometimes there might be a situation where, oh my God, the teacher wanted me to buy all these textbooks and I didn't know about it, and they've all been sold. I need them for the first class. What am I going to do? Okay, go ahead and copy part of the textbook and give it to every single student until you can get the titles. You might think like, wow, I can't do that, but depending on the situation, you might have to. So you just really have to think it through. It's just like a situation. It's like child raising. Child raising is a lot harder than a fair use assessment. So you have to think through, how am I going to handle all these situations? Then you get used to it, and it's not that hard.
Yeah. So I just want to do a quick time check. It's 11:13, so I want to make sure that Carrie has a chance to get through her whole presentation.
I'll just show you. Let me show you what the other questions I got were,
Okay.
and ask you if you want me to go through it. Here's one that's about digitizing a DVD and loading it into Google Classroom.
Yes, please.
Yes, please. Okay, again, if you were doing this, I guess the first thing I would ask is if you own the DVD, that would be a very important thing, and you know that it's a lawful copy and you've acquired it. Okay, good. Then I would go through the fair use assessment. Why do you want to put it in the Google Classroom? Same thing. What is the reason why you're using it in the Google Classroom? Probably for the same reason that you would do it live, I would just say, the same kind of rules apply. Just go through that. The Google Classroom, as I understand it, is private and only accessible to the students. Very good. If you keep it within that framework of the classroom, the fair use argument is stronger. So I think you can do that. I think you can show the entire DVD if it's part of the teaching goal. Maybe you only need to show part of it. Great, then just show part. It doesn't matter what kind of thing it is. If it could be a fact, it could be a documentary, it could be a feature film. If you need to show a feature film in its entirety because you're teaching, then okay. If you're doing it because it's just like, I don't feel like teaching today, so let's just show a movie, not so much. That would not be as fair because it wouldn't be part of that nonprofit teaching thing. Now, I also get people ask me if it's okay to show movies from a teacher's personal Netflix account or their Amazon account. And this is where it gets tricky because the teacher doesn't own the DVD. They don't own the download. Netflix still owns it, and it's your terms are governed by a license. And you do all understand that there's this click-on license, and then you agree to terms that are completely separate from the copyright law, right? And so the terms say you can't do anything with this. That, if you read the terms would say you can use this Netflix movie and, for your own personal non-commercial use, period. Which is stupid because there's some titles that only are available on Netflix. So you might go, I'm going to ignore the license and just go ahead and use it. And you would be breaking the contract. You wouldn't be breaking the copyright law, you would be breaking the contract, which is a state law, which, could be not that risky. It might be something that you choose to do. Again, it's your judgment based on what your institution will allow you to do. Technically, it's a violation. Now, I'm very interested in this topic because I want to see the law change around these kinds of things, because more and more things are only going to be available in a digital format, and they're only going to be available with terms of use click-on license that we can't negotiate. And I'd like to see that change in the law, and I think we can make a good argument because people can't teach. They can't preserve things. I mean, iTunes, you can buy music and you can't preserve it. You're a music librarian. It's only on iTunes. What are you going to do? So I want to know when this happens to you. I want to know, really help me out here. I want to have examples of when you cannot use something that you've lawfully acquired because of a license that doesn't let you negotiate. And there's there's nothing you can do about it other than break the contract or deny the teaching opportunity or use some other title that the teacher doesn't want to use. I really seriously, I want you to email me and tell me every time that happens. Because I'm going to get examples from across the entire world and in every congressional district, and I'm going to, bother the Congress people. And then they will go like, these people need to be quiet. We're just going to give them an exemption for that. And then we can go ahead and just use Netflix.
Have you actually gotten emails from people who said, not that their principal said they couldn't do it or whatever, but that there was an actual legal action because they showed, Pride and Prejudice in class?
No.
Has it ever gotten that far?
No.
Who's going to know? And then they have to care enough. I mean, it seems like the argument is so good for using it that Netflix would look really bad if they tried to, kick. And what are they going to do? Take you to court or just cancel your Netflix account?
But Netflix says they're not going to go after libraries.
I do say that. And the whole thing is, look at the business model. The business model is meant for, consumers to buy these titles. That's the business model that they have. If they change their business model to allow for institutional use, well, they'd have to get all this, change the license, they'd have to sell a license to us, they'd have to have a whole different business model. They might have to clear rights from people that made the movie and blah, blah, blah. And they don't want to do that because we're just a small little part of the market. We don't really matter. So in many ways, they don't even care that we're doing it. Well, if they don't care that we're doing it, then let's have it in the law and let's, create some legal certainty that they don't really care. So that's why I want all these examples. Seriously, I need so many examples.
And somebody
Okay.
get in trouble with Netflix for trying to take him to court, and sort of like this.
Yeah, you could try to set up like a court situation. Unfortunately,
sue me.
Yeah, unfortunately, what would happen is the school district would pay a fine because they would be afraid to go to court.
Carrie, in the example of Amazon, where sometimes you're renting the movie, but you can also purchase a digital copy, does that
Even with a purchase from Amazon, I think it comes with a license agreement.
Okay.
So, you can purchase things outright, and then you're supposed to get all the rights under copyright because you own that copy. Remember, we talked about now you own the copy and you can do things with it. But if they put a license agreement on even a tangible item, then the license governs the use. And this is really great because, it's a bombshell for people that sell content that way because they can, tell you can't do anything. I mean, some of the licenses will say you can't criticize this product. You can't say bad things about our company. That's really bad, First Amendment kinds of issues. And we can collect any kind of data we want on you. We can change the terms of this license and we don't even need to tell you. And we can remove the product from your server whenever we want. I mean, it's we didn't even get to decide if that was okay. So we need to control these horrible things.
The agreement used to say something about you can't use their content for the purposes of committing a terrorist act.
Yeah, right.
They're
Well, when Joe Biden was senator, he was really on the terror on piracy, and there was a report that came out of his office that linked piracy to terrorism. you know, and the first paragraph was just as scary as you could believe. And there is trafficking of money, you know, there is terrorism and there is piracy, and you know, those things are bad, but we're using legal content that we're trying to buy. So you have to draw a line somewhere. We're talking about China, not like a high school teacher, you know.
It seems like if you're a terrorist, having a pirated DVD is the least of the, you know, court issues you're going to have to face.
Right. I'd agree with that.
You know, Netflix is going to have to get in line
Mhm.
way down.
Now, do you guys want to leave now? Because you got things to do? Or
Well,
some of you go ahead, can leave. You can. I have a couple. I think I have one other case study.
We don't have other things to do, Carrie. You're our main thing.
Okay, this was one question. What about a screenshot that teachers embed in their lessons or in the distance classroom? And you use a screenshot from titles that you actually have a subscription to, or their ebooks that you've purchased. This is one of the questions where I would go, why are you worried about that? This is not a concern that you should bother with. You can use a screenshot in the classroom and you can embed it into a teaching tool. That's clearly like fair. Now, what if you didn't have the subscriptions or the databases? What if you just took a screenshot from the web and you put it in, embedded it in your classroom teaching tool? Same rule applies, I think. It's okay to do that. I wouldn't even worry about this. Yay. And then I had one more. This was the one about a math teacher. They have a math textbook. It's out of print. And they've tried to buy used copies, but the sources are drying up. The teacher found the text online. Can they use that text, communicate that link to the students? Probably the title that's online is an unlawful copy. Probably the rights holder didn't want it to go online. They may have wanted it to go online. I mean, you can find that out. But if it's an unlawful copy, then you're really in a situation where you have to think, you know, is this something that I should really do? Now, is there a market impact? Again, you know, I'd go back to the fair use analysis. The market impact is not there because already you're buying out of print books for which the rights holders get zero money, right? They don't get any money in the secondary market. So already, you know, there's no market impact. If the publisher wanted to sell the book, they would make it available in the market. So for whatever reason, they're not doing it, so there's no market impact. Now, the other option is you could contact the rights holder, which would probably be the publisher, and you could say, you know, can I use this link? And they might say, no. They might say, absolutely not. It's an illegal copy. We're taking it down right now. And then you would not have access to the title. And then, you know, that would be the end of it. And then maybe you could take some of the out of print books and you could put them behind, you know, some password protected sites and that the students could go to and maybe use just a chapter at a time. You could do something like that. Another option is you could just link to the illegal copy and just say, I'm just going to take that risk because I got to use this title and this is the easiest thing. And, you know, you could decide to do that. That would be less fair, obviously, and that would be more problematic. So again, it's kind of like iffy. If it were me, I would try to use the out of print books that I have and try to maximize the use of those. Because you're always trying to find more of the textbooks. You're always looking in the marketplace for them. You're always trying to make a purchase. You're always checking to see if there's a new edition. So I would try to use those titles, the copies that you do have, in very careful, segmented ways if you get to that point. And I think that that would be okay.
I have
So
a related question about the links and stuff. You know, for a long time, I've been telling teachers, you know, no, do not, you know, make a PDF of the article and send it to all the students. Send them the link instead so that they can go to the original source. But then there was some sort of issue with links. It was like a Twitter thingy or something, or Instagram with some celebrities and whatnot. And it sounded ridiculous, but you know, somebody's picture of somebody else was linked to the linkety link of the link, and then, but it went to court.
Yeah, I think there was a long time ago too, there were these court issues around like Ticketmaster. Does that even exist anymore? Well, where a ticket distributor was using Ticketmaster, but they were bypassing the front page of the website where all the advertisement was, and they were going further into the website where you could buy the ticket faster, and that went to court. I don't know. I don't think that was settled out of court, but linking in general, linking is not illegal. It's better to link than make a whole copy.
Okay.
I think. But on the other hand, in the preamble of the fair use exception, one of the examples of fair use that Congress gives is multiple copies for classroom use. That's one of their examples. Because when they wrote that, they figured people are going to hand out copies, you know, we're going to mimeograph them and then we're going to hand out these copies. That didn't go away from the law, it's still in there. So in a way, you know, that is considered an example of a fair use. In the digital environment, it's harder to argue that it is because you can link.
Yeah, okay.
So, okay, I'm winding up here. This is the way I think through myself, how I think through a copyright situation. It's, you know, I go through these 5 questions. First of all, are you using the work in a way that's infringing? You know, if you think about it, you might find out, oh, I'm not even using any exclusive rights of copyright. I can do this, no problem. And then I think, what are the exclusive rights that I'm doing? Well, I'm going to reproduce the work. I'm going to distribute it. I'm going to publicly perform it. It's a play. I'm going to, you know, I try to figure out which rights I'm using and then think about, is there some exception to that use? For example, classroom screenings, face-to-face screenings in the classroom are okay. No problem. You don't need, you know, those are excused. Interlibrary loan, excused. Preservation copies, excused. Replacement copies, excused under certain conditions. So, you know, if you might already be excused for the use that you want to do. And then if you don't have a specific exception, then you got to consider whether it's fair. And usually the fair use analysis is the best thing, you know, because the law won't address your particular situation specifically. It'll be something different that you're doing that's not in the law whatsoever. So then you have to think about fair use. And if your use is not fair, then sometimes I'll go to the teacher and I'll say, do you really have to do it this way? Do you have to post all these motion pictures on the live internet to meet your teaching goal? Do you really need to do that? And so, you know, maybe try to make the teaching goal still successful by doing something that's not infringing. And only then do you seek permission. So go through all of these things first. Do not seek permission first, ever. You know, unless you've already gone through the process, it's the same kind of thing that you've always done and you know you need permission. I really saddens me when people go, well, I think I'll ask permission just in case. I mean, that's kind of like, I better just ask if somebody that's really not representing my teachers has a better idea for doing it than I do, you know?
So we ask for forgiveness?
Yes, you can ask. Well, also, you know, there are situations where you ask for permission and they say, no, you can't use it. And then you go ahead and use it anyway.
Ooh, your argument is all of a sudden a lot weaker.
Oh, yeah, but it actually has happened in court where, like, remember that Pretty Woman case where Two Live Crew made a version of the Pretty Woman song by Roy Orbison? They went to the record company and they said, can we do a parody of your song? And the record company said no. And then they went ahead and did it anyhow. And then it went to court and they won. Court didn't hold it against them that the permission was denied. They didn't even, they just went, well, we're looking at the fair use of this only. So sometimes you'll get a no answer and then you'll think, darn it, what am I going to do now? It may be a situation where you just ignore what they said. It depends, sometimes they might want an outrageous amount of money that you don't have. And then if that's the case, I would try to negotiate. Say my budget for the year is $200 and you want to charge me $2,000, that's just not good, reasonable for me. The price of the permission should be reasonable. It shouldn't be something that, you just, because otherwise you can't succeed in your teaching because somebody's trying to charge you too much money. So you're always representing your teachers, yay. So, okay, so then I had these other things. Purpose of the law is to promote learning, fair use, it's wonderful. Licensing trumps copyright law, we talked about that. Just because you can get permission doesn't mean that you should. And then the big, we have a professional responsibility to represent the interests of those seeking to use information because we're librarians. It's part of the creed. So I'm making fun of that, but I think it's very serious. And then you can contact me. I'm really good on email. I'm not as good on the phone, but if you call me, my email will tell me that I have a phone call. So in a way, I get the email. And then can I contact you? This I'm getting back to. I really want to hear about these instances where you cannot use a title because of a licensing agreement. One you negotiate or one that you don't negotiate. I really want as many examples as I can because I'm actually going to try to get examples for every district, congressional district in the country. So the evidence is overwhelming that we need an exception. Can you imagine? That would be something big.
It would be awesome.
It would be so awesome. It would be so great.
Do we have a general GISL email that kind of forwards to whoever's in charge of that at the time, or? I guess that's sorry, Carrie, that's kind of a Matt question, or
okay. Go ahead, Matt.
In terms of you being able to contact the group as a whole at some point.
Yes. So Carrie, you're asking, can you get in touch with our members?
Mm-hmm.
Yes. Mm-hmm.
And I want you to even individually, if something comes up, and what I want to know is specifically what was the teacher trying to do,
Mm-hmm.
and what was the title that you were trying to use,
Mm-hmm.
and was its availability only on that platform? That kind of stuff. Did the teacher have the copy or did the library have the copy? All those things, like the whole situation, because, when you do advocacy, people like to have stories because the Congress doesn't know what's going on in the classroom. They really don't know because they got so many things they're thinking about right now. So we have to go, well, there was this teacher and they were teaching history and they wanted to do this and then they couldn't. We have to be able to tell them a story so that they get it. And it's got to be a story from one of their constituents. And it's got to be a school district that's in their congressional district. And it's got to be, a university that's in their district. And, we start talking about it because we're using taxpayer funds to buy stuff we cannot use. That should be kind of a big issue.
Well, Carrie, thank you so much. I'm glad that you ended with, represent your teachers. Many times I have said to, the shock of some of my colleagues, I don't work for whatever publisher. I don't work for the copyright office. I work for my school, and my job is to make sure that my teachers and students have what they need in order to meet their pedagogical outcomes within the boundaries of the law. So
Right.
I am not the copyright enforcer at all. I am the copyright informer. And then I will often say to my teachers, well, here's what the law says. And now you, teacher, you decide what you're going to do. It's not my call to make as the librarian.
Right.
It's yours or the principal of the school or something like that. I feel
Yeah.
that things that I read online and blogs and Facebook posts, it seems like librarians so often, because as you mentioned, we're rule followers, so often sort of take on that role of the copyright enforcer and telling people what they can and can't do.
Yeah.
And,
And man, I get reamed out on some of those listservs.
mhm.
What do you mean?
I
You know, they're like, you're horrible. Don't you want authors to make money? Like,
Yeah.
sure, I want to make money too. Everybody wants to make money. I mean, you know, you chose a position, profession that's kind of difficult to make money, just like I did being a librarian. I'm not going to make a lot of money.
And I think when we do certain things, we are facilitating the way they make money. For instance, when I say, no, you can't really buy 5 copies of the ebook and push them to 30 iPads. You really, because that is a clear violation of getting around paying, you know, then we're facilitating the creator in making
Yes.
as often as we are maybe, you know, snatching it out of their pockets or whatever.
Yes.
I just wanted to add, because what you were saying, Matt, reminds me, there's a like a business thingy, you know, good old Robert Kiyosaki and real estate and such. But it's like, instead of, and maybe this is one of what we as librarians think about, is like, instead of saying, well, we can't do that, we say, how can we do that?
Right.
Yeah.
And as I'm the copyright officer, I've been copyright officer at several independent schools now for almost 20 years. And that's always the way that I've approached it, is that I'm not the police. I'm not going to go around looking for people who are infringing, because you do know it is happening somewhere. But when people do come to me and ask me, can I do this? Like, I'm looking for a way to make it happen. And I'm hoping not to give them a no.
Yeah. It's Matt is so right though, because there's a lot of people that are just, they're fascists out there. They're so afraid, and I don't know. I think some people like to be like, they have like this little power thing going on. No, you can't do that. Never. You know, I'm in charge.
Carrie, do you have about 5 or 10 minutes you can still hang out with us and answer a few questions?
Sure.
Okay, there was one that came in through chat, and this question says, if a school purchases an umbrella public performance license from CVLI/MPA, does that supersede the Netflix/Amazon agreement for educators in the classroom?
Such a great question. And
that's from Angela Williams. Angela, you get credit for that great question.
That is a great question, and I don't know the answer to that. I mean, it's part of the problem that we're trying to solve. You have competing licenses. If it were me and I needed to use, I don't know. It's hard, because if you acquired the title by clicking on something, agreeing to some terms, that would be an assent to agreeing to those terms. So I'm pretty sure the Netflix license would override, even though you have a blanket license. So you're paying for something and you can't actually use it fully. Got to remember that. That's a good example.
There's a question from Kim. She wanted to ask about the Internet Archive and the National Emergency Library.
Yeah. Well, the Internet Archive for more than 8 years has been doing this open library where they get a print copy and they digitize it and then they lend it out one-to-one. And they don't get any authorization from rights holders. They tend to do older books. If a rights holder contacts them, they can take the book down. And that's what they've done for 8 years, and no one has tried to sue them yet. Now they've done this emergency library, which allows for multiple copies. I think that given the circumstances, it would be very unlikely that anyone would sue them during a global pandemic where their argument is we're trying to serve all these students that don't have access to their books because their books are in the school. I think in an ordinary situation, it would not be probably lawful to have multiple users on those books. There are some aspects of the open library itself that I think are kind of iffy. But on the other hand, it's been more than 8 years and no one has sued them. Now, I'll tell you, the Authors Guild has gone to, yeah, no one has sued them. Brewster Kahle, who is the founder of the Internet Archive, is an inventor. And he has some patents, and I believe he has a lot of money. People say that he has a lot of money. The Authors Guild, who would like to sue them, they have no money. They have no money whatsoever to bring a lawsuit. The Publishers Association, some of the publishers have a lot of money. Some of them don't. The ones that have a lot of money don't really care about this issue. Those are the Elsevier's and those people, they don't really care about this, you know, lending trade ebooks kind of thing, or school books. They don't really care. You know, I know that the Authors Guild has gone on the Hill and they've tried to, you know, tell Congress people to do something about it. And the Congress people haven't done anything about it because they're probably like, what do you want me to do about it? If it really is a problem, why aren't you taking this to court? And then if they took it to court, let's say they had the money and the decision ended up being in favor of the Internet Archive, the genie would be out of the bag, and wow, that would be like a bad decision for them, really, really bad. And they're hurting. The Authors Guild is really hurting, and authors are hurting pretty badly. So it's kind of a risk. They do have the opportunity to take their books down, and they go down immediately. So maybe that's how it's going to just continue to exist.
And Carrie, just for people who are unaware, the recent controversy is that previously the Internet Archive, as you mentioned, would check out books one-to-one. So only one person at a time could check it out. But during the pandemic, they have changed that so multiple users can access a book at the same time. That's right, isn't it?
That's right.
Yes.
That's right. And I don't know how much that's really being used by schools.
Mm-hmm.
It would be interesting to know if there are actually schools that are going, oh yeah, this book in the Internet Archive is exactly the one I was going to teach.
That would be interesting.
You know, I don't know because I don't know. I mean, the Internet Archive would be kind of not very smart to put like To Kill a Mockingbird.
Mm-hmm.
You know, that would be something that would not be smart for them to do. I think they're pretty selective on what they put up.
Yeah.
They still have a, it's not restricted, but there is a little bit of a barrier because you have to sign up for an account, even for the multiple simultaneous checkouts. I'm using this like crazy because I have 5 10th grade US history classes.
Oh, great.
It's with no physical library. I mean, I've gone to the library and checked a couple things out and left them on a bench for kids. But I mean, it's been a lifesaver between, you know, what you can find in the Internet Archive and then what you can find just, you know, various random other places or other portals that you end up at the same thing. It's been a lifesaver. I just don't think that there's any way that, you know, authors can, even authors would have a leg to stand on in terms of this because, you know, I don't think it's a market that they would have had otherwise. But anyway.
It's a good point.
I had a question. I have a lot of questions, sorry. This is a situation that that I've been in right now because we are coming up to the end of the term and we have a short term and I mean, it is movie heavy. It is lots of film classes, thematic film classes, et cetera, et cetera. We've purchased a streaming package, a lot of us, I guess, have, that has a lot of stuff that can be streamed for independent viewing. It can sort of kind of be screen share zoomed, but there are things. I have one teacher who had 3 movie requests. Actually, I have, I guess, 5 movie requests that I cannot find online in any version anywhere. It's like, well, it's not in this package. It's not in Canopy. It's not in any of like the Hooplas or whatever, that kids could watch independently if they signed in. They could watch independently if each one had a Netflix account, but we have kids who don't even have internet, so they don't have Netflix, and that's a barrier. And yet, but we own all the DVDs. We own, this random funky movie in like, Mongolian, and it's just not available anywhere else. But DRM has locked it down. Has anybody tried this? So that you can't play, and they didn't do this just for streaming, but you can't play a DVD and have any kind of other video capturing whatever. And I see it if you were, trying to copy the DVD from the library or something. But if you have a DVD in your player and you're trying to screen share it via Zoom, the screen grays out. You can't do it. They've just got that on there. I don't know of a way, but if there were a way found, so that this, random thing in sub-Saharan African desert, something, if we could find a way around the DRM for an educational thing that we own the copy, that the teacher uses specifically for, this instructional purpose, how strong would that argument be? Just out of a argument question.
Well, right now, if you could circumvent the technology, it's okay. Because there's a rule-making process that we go through every 3 years where it has to do with the Digital Millennium Copyright Act, and I don't want to get into all that, but what happens is we make a case that in some instances for certain works, technology can be circumvented in order to exercise a fair use. So right now, you can, the rules only last for 3 years. And right now we have an exception to that rule. So you can circumvent that title and it's not illegal.
Okay.
So if you can figure out how to do it, you can do it.
Oh, that's really interesting. That's really good to know.
Yeah.
I mean, not that we would tell anybody if it were,
Yeah.
but it's good to know. It's a good, that we have 2 legs to stand on and not just like a knee.
Yeah, at first, when we got the exemption, at first it was only for people that taught film studies.
Mm.
And then we went back and we asked for like more, it's any teacher. We showed that any, teachers that are doing criminal justice law or something show movies, So then we got it expanded, but only to higher ed. And then we got it expanded to higher ed and K through 12. So right now you can do it.
And when does this particular 3-year cycle end?
I believe it's next year. And it's a very long process. And I'm very confident that it's going to be one of those exceptions that's going to be permanent. They can make some exceptions permanent. And I think that this is going to be, you can go ahead and circumvent. It was hard because, the motion picture people really didn't like this.
Yeah.
At all.
Knocked it down pretty hard with that DRM stuff on DVDs.
Yeah.
Those keen little hacker minds, I'm sure there's something out there somewhere.
Somebody knows how to do it.
Yeah.
Well,
I actually have a t-shirt that has the code printed on it that I got like years ago, how to circumvent at least the kinds of stuff they were doing back then.
Be the same as like the build a bomb, posts on the internet. Post it for us all as hackers.
I'm going to step in here because we're running low on time and we do have just a little bit of GISL business to do before we all adjourn at noon. But before we let Carrie go, any last minute quick questions for her?
And for sure, send me an email if something comes up.
Carrie, I can't thank you enough. This has been so informative.
It was nice to get out. Feel like I was with people, you know?
Well, we appreciate it, that is for sure. And also, just to let you know and everybody else know, we have 2 copies of your book to give away.
Oh,
Yes. So we'll probably do that in just a few minutes.
oh,
Have
great.
a random drawing.
I'm going to write another book.
Are you?
Decided. I'm going to write
Okay.
another book for K through 12 again.
Yeah. Okay.
Same, just an updated kind of thing or different topic?
I think it'll be an updated kind of thing. I really think that school librarians need a lot of help because they're just, lots of times you're the only one in the school,
Yeah.
or you have 5 schools, and it's so easy to just go, I'm so busy. No, you can't do that. Blah blah blah. I think they really need a lot of help and coaching. So that's what I'm going to try to do more of.
That'd be great. Yeah. Well, thank you again. I appreciate it. And
Sure.
Kim has a fuzzy dog and she wanted to show it to you.
Okay, good.
Karen, you have
He
your
took
fuzzy
off.
dog?
Oh,
He was in
Kim.
the meeting. I can put his picture in the chat window real quick.
Okay.
He said Scruffy dogs.
I love Scruff.
His name is Scruffy. His full name is Scruffy Looking Nerf Herder, which is a Star Trek
Oh,
reference. But
And I see Jennifer has a cat. Love it. I have a cat. I have a cat right now.
so I stuck his pic in the chat because he took off. He apparently licked all the crumbs out of my keyboard already, so he lost it.
that is a cute
Okay.
Scruffy dog.
Public service.
He's 8 pounds of sheer terror.
Oh, he's cute.
Yeah, we like him.
Yeah.
Thank you for indulging me, Matt.
Oh
Of
yeah.
course.
The animals and pets are they're so important.
They really are. Well, thank you again, Carrie. And you take
Sure.
care of yourself, stay safe, and wash your hands and all that kind of good stuff.
Yep.
Yeah,
I'm
you
drinking
can.
a lot of hot liquid with
Thank
lemon in it.
Oh,
Oh,
okay.
thank you.
All right.
Thank you very much. I had a good time talking with you.
That was awesome.
Thank you.
Talk to me too. Tell me about your problems. I want to hear about it. All your problems, just send them. Okay, bye-bye.
Bye, Carrie.
Bye. Hey, well, the board did not meet prior to this Zoom meeting, but I mean, I imagine we have a little bit of business, GISL business to mention. So at some point, because most of the membership is not participating in this call,
Oops.
things that needs to be addressed is the presidency for next year. Matt will be rolling into the president's role, and I will be rolling out. Look at him with all that power handing over to you. So we will need a program coordinator. And so I feel like perhaps a Google form calling for nominations or voting should go out to do that, because most of the membership is not in this call right now. Does that sound like something that is reasonable? Okay, so we'll follow up with that with the whole group. And then in terms of any other business, Nez, I'm not sure if you had anything in terms of treasury report. We weren't asking you to put
Wasn't incurring any. I mean, I paid the annual registration to maintain us as an official corporation in the state of Georgia, and I submitted the taxes, and that's about it. I mean,
Awesome.
I think I've had one membership come in since pandemic 2020. So.
Okay, and Matt, you had asked if one of your queries originally before this meeting was if people wanted to meet again or before the end of the year, and what were the results of that?
Generally, yes. We have, after this week, 3 more weeks of school. I think that and maybe this would be a good place to for everyone to either raise their hand who's here, or use the raise hand feature to let me know what you think about this. Two topics that came up that we thought might be interesting for people to talk about just in a more of a sharing session are what challenges and opportunities has the pandemic provided to us as librarians. Because for me, on the one hand, you know, it's a drag that I'm not in my library and I don't get to see my kids, but I've learned a lot of really interesting stuff and have been doing activities that I think I will continue doing. So there is some good that's come out of this. So that's one thing that I would like to hear from everybody about. And then the other thing was, what are we going to do? What is everybody going to do about the end of the school year? I think this was especially in terms of getting materials back, sanitizing them, quarantining them, things like that. So we could either have one meeting where we talk about both of those things, again on Zoom, or we could have two different meetings. So that's what I'm thinking.
Okay.
Ideas, thoughts? People are raising their hands. Carrie says one meeting. Pascal, one. All right. Well, there seems to be, okay. So we'll have one meeting and we'll talk about those two things, and I'll arrange it and send that information out to you.
But I still think it should be at the end of the day so we can have a happy hour at the end.
Okay.
Y'all, people, this is my social life.
Okay.
I'm just telling you that faculty meeting on Wednesday afternoons,
Yeah.
and a virtual happy hour on Fridays with my faculty people is my entire social life. So I'd love to have a party with y'all.
All right.
I will bring along my box of wine because that's what I've moved on to now. So
Because then you only have to go to the grocery store every so often, right?
Yeah. Well, the thing now is it's not AM and PM, it's coffee time or wine time.
That's right.
And that is a shifting line in the sand. It moves from day to day.
Well, okay, I have to actually leave right now. My husband has a 12 o'clock appointment, so this is what we do all day long. And so thank you everyone for
but y'all hang
joining.
out. We're going to do the drawing right now to see who gets the book. Can you hang out for a minute, Lisa?
I can hang out for a minute. I don't need the book. I have it. So.
Okay. Here's what I'm going to do. I'm going to use a random number generator to generate a random number. And then whatever line number you are on the Excel spreadsheet that your RSVP is dumped into, that's your number. So did anyone not RSVP who's here today that I need to put in there? All right.
I did very last
you
minute.
Ready?
No idea.
Okay, as long as you're in there. 28.
And whoever wins, send me your personal address and I will have the book shipped directly to your house.
28 is Pamela and I. And then the second book, two is Leslie Wachter. So Pam and Leslie. Yay for you guys. So we will get you your books.
Awesome.
Okay, I don't think Leslie's in the meeting.
Oh, is she not here in the meeting? That's okay.
No. Can you email her and CC me so I can get addresses?
Yeah, I'll email both of them. Yeah.
Perfect.
And you. Get everybody in the same loop.
Yep.
We have one final message. Oh, Pam says, wow, thanks. You're welcome, Pam. Okay.
Congrats.
I guess that's it. Is that
Well,
it?
this has been great. And what's really sort of ironic about this whole thing is that the board had been talking about perhaps doing some type of Zoom meeting so that we could include people from further away than the Metro Atlanta or people who can't get to the meeting. That was something that was that we were discussing earlier before all this happened. So this was actually a really good opportunity for us to give it a try and see how it goes. And perhaps we may do things like this when things are back to normal.
Whenever that
as
might
well.
be.
Yeah, hopefully. But all right, with
All
that,
right.
peace out.
All
Take
right, you
care, everyone.
guys. See you later. Wash your hands. Stay safe.
Bye.
Bye, everybody.
Thanks, Lisa.